My name is Zimerman. I'm a senior staff attorney at the Electronic Frontier Foundation. For those of you who aren't familiar with EFF, we are a nonprofit civil liberties organization. We focus on free expression, civil rights, and the intersection of technology and emerging technology and civil liberties. And the way we do that is we are litigators. We take cases, we take impact litigation cases. The idea being we will represent people not only to help them out, help defend their rights, but to really create, try to create precedent, try to create law that will help other people down the road. So I'd like to begin today by talking about anonymity, free expression, and the law. That's a pretty broad topic, obviously. So I'm going to talk about something a little bit narrower within that, and that's really how do targets of criticism use the law to try to unmask and otherwise try to stop speech that they don't like. But I want to first start by picking up on a few threads that were raised yesterday in Bruce Sterling's talk and in Rave's talk, and that is by taking a moment and thinking about the advent of cloud computing and this notion of computing power increasing dramatically over the last several years, and really creating some powerful applications that allow end users to really do amazing things, both personally without any kind of intervention from other parties, really doing some really amazing work, especially in the activism space. But at the same time, the cost of computing has gone down dramatically, and it allows people to take advantage of third-party cloud computing applications. So effectively what that means is that you're outsourcing the task of performing these computerized applications to third parties. Now, Rafe asked the question at the end of his talk yesterday about whether you can trust Google, or whether you should trust Google, or any third-party application provider for that matter. And I think that's an important question that you need to keep in mind as we think about the role of anonymity, the viability of anonymity. But there's actually a better question, and I think that is, think about what rights you want to maintain, what control you want to maintain over your communication. Because when you outsource the task of creating your expression, creating your activism, you gain a lot of benefits. You gain a lot of benefits from reliability and gaining expertise, not having to have people in-house to be able to perform these tasks. But it also means that there are other people in charge of your rights. So if you find yourself in a situation as an activist wanting to do very dramatic things, want to do controversial things, when the people who you are criticizing come back, you might not have the ability to directly influence whether your rights are actually maintained or not. And it's a larger question than simply cloud computing. It's I think better metaphor for the online and free expression space is an imperfect one, I will grant you, but it's the idea of a chain of intermediaries that allow you to communicate online. And just to take a moment and think at the outset here about what links in the chain there are, what are all the different players that need to be functioning to allow online expression. So everything from domain name registrars to web hosts to ISPs, all of these players play a role, and from the legal standpoint, especially in the United States, they become very tempting targets of people who are criticized by anonymous speech online, and end up, these various links in the chain become vulnerable targets for people who want to take down speech. So something to keep in mind in the big picture here as we're going through all of these possibilities. So back to anonymity. Why is anonymity important? Why would anyone actually want to express themselves anonymously as opposed to just coming out, identifying themselves, and going in that direction? Well, I have a quote here from a U.S. case. I promise I'm going to try to keep the legality to a minimum here, but I think this opinion does a good job of really highlighting why it is that we care about anonymity. And the court here says, I think very clearly, that the decision in favor of anonymity may be motivated by fear of economic or official retaliation, by concern about social ostracism, or merely by a desire to preserve as much of one's privacy as possible. Seems like a relatively straightforward notion, and I think they get it right. So, especially with this advent of improved applications over the past several years, there have been some really, really exciting projects that have hinged in one way on anonymity. And on the flip side, there have been very aggressive moves by targets of this kind of criticism to somehow try to interfere with people's right to express themselves, to somehow retaliate against this kind of criticism. And I just want to go through a few examples here. In November of 2008, New York residents were surprised to hear when they were handed free editions of a special edition of the New York Times that the Iraq War had ended overnight, apparently. And that a number of other great things had happened, that America had passed universal health care, that the UN had passed a global atomic weapons ban, that George Bush had actually been indicted for war crimes for lying about getting into Iraq. That even to New Yorkers, or especially to New Yorkers who are a tad bit jaded, they quickly saw through, but really appreciated the effort of this really elaborate hoax that really made people step back and think about the possibilities and what was likely to be and what actually was happening. Another hint was that the date of the newspaper was July 4th, 2009. That is Independence Day, eight months in advance. So people were keyed off pretty easily. The site is actually, the newspaper is actually at, you can see it right now, even it's at nytimes-se.com, that's -se for special edition. But not everyone found this to be terribly amusing, and as lawyers are wont to do, the New York Times lawyers were not terribly pleased with this. So once again, as lawyers with too much time on their hands are wont to do, they tried to start a legal process to get this content to go down. And that's what they did. They fired off a legal threat and sent it to the web hosting company who was hosting this website, and said, well, since the site is using our logo, you're using the New York Times masthead. This is clearly illegal, and this material has to come down. They weren't terribly successful, although the New York Times itself wasn't exactly the most annoyed by this prank. Inside this edition of the New York Times, there were some specific advertising blocks where advertisers were taking far more socially responsible, shall we say, positions than they might ordinarily do. And one of those was De Beers, the diamond company. I don't know if you can read the text on there, but the ad is of hand reaching for a disembodied hand, and the text says, your purchase of a diamond will enable us to donate a prosthetic for an African whose hand was lost in diamond conflicts. De Beers not terribly amused by that a bit of social commentary, and they got upset too. So what did they do? They tried the same tactic, and again, this is a trend. And what one might expect in response to anonymous speech where the identities of the perpetrators aren't known. De Beers took to targeting the domain name registrar, not the people who made the comments, not the people who created the website, but actually went after the domain name registrar and said, you need to shut down this entire domain name because there's an ad on here that we don't really like. Now, interestingly, the domain name registrar in this case actually was located in Europe, I think in Belgium, and they received this notice. The solution from the U.S. or from the activists was to move the registrar to a site in the U.S. for reasons that I'll discuss here in a minute about why that might be advantageous. Another example of recent social commentary that has relied on anonymity is obviously the social protest movement, Anonymous, that has been very active in supporting WikiLeaks across the world. Now, this is still a very active issue. There are certainly efforts by members of governments and others to try to retaliate against or stop in some way the work that Anonymous has done and others in kind of this general WikiLeaks anonymous space. Anonymous has introduced a lot or begun a lot of social protests against organizations that drop their support or drop their networking agreements with WikiLeaks in the past. So it'll be interesting to see how that plays out. Now, notwithstanding the international elements of these last few examples, frequently and disproportionately so, these kind of disputes that have to do with anonymous speakers end up taking place inside U.S. courts. And there's a number of reasons why that happens. One is that a lot of the companies that are involved in enabling speech are simply U.S. companies. They have servers within the U.S. They have the U.S. courts have jurisdiction over them. You know, if someone is speaking on Google or Facebook or Twitter or any number of other companies, these people end up being people who engage in anonymous speech end up being targeted through the legal process in the United States. Now, that's actually really good, oddly enough, that people who are engaged in anonymous activism end up being targeted in U.S. courts because the legal protections are very, very strong in many key respects, not only for the intermediaries themselves, be it the web hosts or the domain name registrars, things like that, but also because the legal protections for the speaker are actually very, very high in the United States. If you're engaged in anonymous activism, being in a U.S. court is actually something that in a lot of respects is very good and something that you might actually appreciate, at least on a substantive level. That's partly because the U.S. First Amendment protections tend to be applied uniformly across the board, not only just for U.S. citizens, but also for people who are using services inside the United States, even if they engage in speech when they were outside of the country. So why would litigants actually want to sue anonymous activists inside the United States if the legal protections are so good? Well, partly is notwithstanding the very good substantive protections, the U.S. system is very inefficient in a lot of ways, and there are a lot of very rich companies who have very well-paid lawyers who look all the time for ways to exploit the U.S. system, and they've found that the U.S. system is actually very good, even if you have these strong legal protections. It's a very good place if you want to try to use the legal system to try to unmask an anonymous speaker. And there's a couple reasons for this, a couple components of this inefficiency. One is that it's very cheap to file a lawsuit in the United States. It's very easy to start the process of using the court system, using the legal system to try to unmask a speaker. Typically, it's by using something called a subpoena. It's a legal process sent out to a third party asking for information about, say, a subscriber. Sometimes in the U.S. you don't actually even need a lawsuit to start this process. You can simply go to a court and say, look, I have this great case, I'd really like to bring this lawsuit, but I don't know who this person is. So can you use investigatory powers of the court and find out who this person is for me? When that is actually, in a lot of these cases, ultimately what the litigants are actually looking for. Litigants can compel U.S. companies to turn over the identities of anonymous speakers, even without court oversight, which is a really another great feature in terms of what plaintiffs are looking for. Because not only can they start the process, court isn't even going to pay attention. And when you don't even have the target of that investigation having a say as a practical matter, plaintiffs look at that as a really great deal. Now, it might be different down the road if they actually get into a court battle. They might find that they're going to lose, but more often than not, because of this inefficiency, plaintiffs are nonetheless really liking being able to come into the U.S. to use this process. Oddly enough, especially for a European audience, companies are not obligated to let the targets of this investigation know, even in civil disputes. So even if you go to, say, an AT&T or to Google, These companies aren't actually even obligated to tell you, the subscriber, that your information is being sought. Again, another great feature for someone wanting to silence speech or somehow unmask someone who is engaged in kind of controversial communications. Now, as a practical matter, it doesn't really matter. Gmail, or Google, I should say, Yahoo, Twitter, the other major players, as a matter of course, do give users notice when their information has actually been sought. But typically it's about in a 2 to 3 week range. So think for a second about how this plays out in practice. You might have just engaged in a really controversial, really successful activist campaign. You might have performed or pulled off that fake edition of the New York Times. You've made people really mad, and in the middle of that, the highly paid lawyers for the plaintiff, they start the legal process. They send a subpoena to Google, and then Google responds by sending you an email. So you're supposed to check you're supposed to apparently always be looking at your Gmail account or whatever other provider you're using, and it says notice of subpoena. It says you subscriber, your information has been sought. If you don't do anything, that's great. We're just going to go ahead and turn over your information. If you actually do want to do something about it, then you should actually get a lawyer and go to court and file something within 2 to 3 weeks. It's not the most practical, not the most speaker-friendly system, which leads to a lot of these cases never actually being litigated because the information is turned over because someone didn't check their email, they didn't check their spam folder, they weren't paying attention, or they simply didn't know. They simply didn't know what to do. So I just want to run through a couple examples of how this actually plays out in practice, and what kinds of litigants we have. What are they doing, and how are plaintiffs seeing this as such an easy system to game in some respects? So this example is a case we were involved with a few years ago. A New Jersey chief of police decided that he was really tired of being criticized on the local message board, and what was the terrible comment that he didn't like? Well, apparently someone on the message board said that now we have a chief who needs a full-time assistant to do his work. That was apparently the really controversial comment that he didn't really like, and he wanted to use the legal system to investigate. So what did he do? He followed the blueprint I laid out before. He filed a suit, issued a subpoena, and waited to see if he was going to be able to get that information. There's another well-known case in the U.S. The next year in 2008, I believe, where a fashion model really got annoyed at someone calling her mean names on a blogger.com blog, called her such names as skank and old hag and some really unpleasant things like that, some general insults like that, and she went to the court and said, I really want to know who said that. And this case is interesting because it's rare that you actually have the people bringing these cases kind of admit to what they're doing, and this is one of those cases where she said, and when I find out who did it, at least I know who my enemies are. Well, that's not really what the point of the legal process is. That's not what the legal protections are supposed to do. You're supposed to go to the court if you actually have a legitimate complaint, you're supposed to go there to pursue it. You're not supposed to use courts as this private investigatory tool, which unfortunately too many litigants actually use it like that. So the system becomes really attractive to international litigants, as it turns out, because of all these features that I've discussed. You have a very easy system, and especially if you're talking about people who have engaged in speech overseas, and you can somehow go bring a case in the U.S., what are the odds that an activist or someone else engaging in speech is actually going to hire a lawyer in the U.S. to litigate this question that might be bogus at the outset? Pretty low, and I think that's the risk that, or the chance that a lot of litigants actually take. So, a few examples of that. This is one of my favorite. So Dennis Hamlin is the CEO of Universal Music Australia, apparently a rather loud or a very boisterous person, as I am led to believe. Someone made a fake Twitter account for him, and to underscore the point, to make sure that you knew it was a fake Twitter account, like a la fake Steve Jobs, he said faux Dennis Hamlin. Actually puts faux in the title there to make sure that you actually know that it's fake. And as if that wasn't enough, in the bio, I don't know if you can if you can read that. But under bio it says, Sony Music Australia CEO, I like red wine, tequila, making money, signing washed up has-beens, and good haircuts. So it seems rather obvious to any observer that this is a spoof site. The tweets weren't anything defamatory. They didn't actually imply that the tweets were defamatory. Instead, Universal Music sent out a subpoena, a pre-lawsuit subpoena, saying that there was copyright infringement. But what's the copyright infringement, you say? Well, that little low-resolution picture, that little black and white picture, taken from the Universal Music Australia website, that apparently was it. That was the great crime that was committed, that someone took a little thumbnail of the CEO and put it on the website, which is, of course, nonsense, that was actually what they were concerned about. He just didn't like criticism. So, but again, you have an Australian CEO. You don't know where the Twitter user was. Presumably, there's no reason to believe that the user was in the United States. But the plaintiff here thought it would be a really, really good idea to use the system, because who's going to fight back? And finally, speaking of good pictures, have this one here. And this series of cases that I want to mention really briefly is not about activism, but more on online file sharing. But the underlying legal principles are the same. In this odd phenomenon of the last year, a number of pornography producers have gotten the really, really great idea that a way to get copyright settlements for their works is to monitor BitTorrent swarms, figure out who's downloading their movies, then rush to court and literally file lawsuits where thousands and thousands and thousands of people are sued at once. So judges don't know exactly what to do with this, and so the process starts, and before anyone knows what's going on, subpoenas have been sent out, people's identities have been disclosed, and then individuals like our friend Mr. Stone here send out settlement letters saying, well, we just found out that you downloaded this pornographic film. It could cost you $150,000 in a lawsuit. If you give me $5,000, we'll go away and we'll make sure your name never comes up, mentioning that you actually like to download this kind of pornography. So we have problems with that strategy. It will be interesting to see how it plays out. But actually, I don't know what this picture is from. It is of him. It's been used in a number of newspaper articles. But I do love it. So how do these cases play out? Luckily, for the people at least who exercise their rights, they find that the First Amendment to the U.S. Constitution provides very, very good protection to kind of weed out these very bad, these very unfortunate cases. And where do we get that? Why does free speech mean anonymity? Well, again, going back to a court decision, this is a U.S. Supreme Court decision. The idea is basically that anonymity is a shield from the tyranny of the majority, which I think is a good starting point, and it's something that's very firmly entrenched in U.S. law, and it actually benefits activists from all over the world who find themselves stuck in a lawsuit like this, where their identifying information is sought. The U.S. Supreme Court hasn't actually dealt with an online anonymity case yet, so the actual details of what the tests actually are end up being worked out by the lower courts. But essentially, and there's a lot of variation in these cases, but essentially the rule is simply, if challenged, if this process of sending out a subpoena is challenged, then the plaintiff basically has to go back to court and explain why it is that this isn't just a garbage lawsuit. Why isn't this just a trumped up excuse to try to get identity information? And that little bit of protection, that turning the screws, turning the tables a little bit, actually does a really, really good job of weeding out a large portion of these lawsuits, because it increases the cost for the plaintiff, it actually gets the court paying attention, and it actually, effectively at the end of the day, leaves a lot of individuals with their anonymity protected, which is great. There's still the matter of expense, that who can actually afford to do this. We do. There are a number of attorneys that we work with who like these cases, who volunteer their time to do this. But it's still a relatively small portion of the huge number of lawsuits of this type that are filed. So expense is still a big question to think about in the context of these cases. Now, in addition to the First Amendment, there's also this great development, this other great legal protection called Antok Slap laws. SLAP stands for Strategic Lawsuit Against Public Participation, which is just a long way of saying lawsuits that are intended to chill speech. And a number of states have passed this in the US. They get implicated frequently in these kinds of cases. And basically the court looks at it and says, was the intent of you filing this legal process, was the whole point of it to silence critical speech or to somehow infringe on the free expression rights of individuals? And if so, if the court decides that it is, then the court then will, once they get rid of the lawsuit, they award attorney's fees for the speaker, which is a big deal in U.S. system. Again, something that might sound a little screwy to many of you, but it is a system where it is not a winner or a loser pays system. Everyone pays their own legal expenses in the U.S. So it becomes a big tool to balance the sides of these kinds of disputes. There's also federal law being entertained as well, and hopefully we'll have some kind of nationwide solution here soon. So how did these cases turn out, the ones that I mentioned before? First guy, Donald Ingrassalino, the New York police chief. He had his case adjudicated. We had a good friend who's an attorney in New Jersey litigate this. Court looked at it and said, someone's saying that you need an assistant, not exactly defamatory, not exactly actionable. You don't get to get the name of your critic, so the case was dismissed. How about Dennis Hamlin, the Universal CEO? He didn't actually file a lawsuit. I had a number of very fun conversations with his lawyers, trying to point out to them how ridiculous this was, and do they really want articles written about how their CEO was being a bully. They quietly dropped the suit and went away, which was kind of fun. Evan Stone, who was the porn lawyer, his success rate and the success rate of other lawyers like him is relatively mixed. Unfortunately, over the course of the past year, over 100,000 people have been sued in this manner in U.S. courts for downloading pornography, and that's just within the last 12 months or so. They have unfortunately been very successful, and regardless of whether they did anything or not, they've been very successful in many cases of pushing through these subpoenas to be able to get the identities of people and to send out those kind of nasty letters to encourage them to settle, again, whether or not they actually did anything wrong. I think the tide is turning a little bit. It takes a little while in the court system, a little bit, to get a trend moving to stop that. But I think judges are getting tired of being manipulated like that. So hopefully we will soon see a shift in the success rate. Finally, Liskula Cohen, the model, she actually succeeded. There was a court hearing on this. The court looked at it and decided that saying, making mean comments, like saying she was an old hag and a skank, that was potentially actionable, which as a First Amendment lawyer, someone who cares about free expression, I think that's actually wrong. But I can kind of I can understand what the motivation was of the court, and I think it's another good instruction for people engaged in activism or other kind of critical speech. When you have cases that are closer to the line, when your speech seems to have less utility, if you're not making any kind of larger social point, I think courts are going to be encouraged to they're going to be encouraged to bend the rules a little bit, or at least in a close case, they're not going to look very favorable on what you're doing. So it might be a useful thing to keep in mind. So these are all civil cases that I talked about. These aren't criminal investigations. What's the rule in criminal investigations? Well, unfortunately, law enforcement has a much easier time to be able to get this kind of information than can civil litigants. The cops basically just have to go to a court and say, or should go to a grand jury, I should say, and say this would be relevant to our investigation. And that's pretty much all it's going to take for that information to be disclosed. Most of the time, it doesn't really matter, or at least it doesn't matter to me in kind of a policy sense, because most of the cases that we know about, at least, are in a different kind of context. We're thinking about things like phone harassment or other kinds of anonymity that's quite separate from the activist space. But I am concerned about it because of the increased, very aggressive use of anonymity in a way that tends to piss off governments, such as in the WikiLeaks case. There has been a much more aggressive response, or at least the beginning of an aggressive response from the US government. And I'm getting a sense that they're going to continue to try to use these kind of investigatory powers to go after people, try to investigate people who may actually have been engaged in protected speech, but nonetheless use that speech in a way to try to very heavily criticize the government. We haven't been involved in a case that's directly like this, but we have been involved in a recent case that's kind of tangential to the WikiLeaks situation. Recently, you might have heard about it, that the US government had sent legal process to Twitter to try to find information about a number of people who have been known or suspected to be associates of WikiLeaks, including an Icelandic member of parliament who we ended up representing recently. And it's a very interesting situation. The court has not been convinced so far that these kind of protections should extend and block law enforcement from doing this kind of stuff. But I think this is certainly not the last case of this type. So a lot of different things to talk about, but out of time. So I'll just leave you with a few important points here to hopefully take away. One is to think very hard about the kind of digital footprints that you leave behind. Not only the digital footprints, but what kind of third-party services that you're going to use. Are they going to have your back or not? Do you have the ability to be able to exercise your rights if you want to engage in anonymous speech? Who in the chain might rat you out? Who in the chain is going to stand up for you? These are important questions you should think about ahead of time before doing some really controversial activism. Two, and a topic I didn't discuss at all, really think hard about using anonymizing technologies. All of these hoops that you have to jump through here, these are all things that you have to do when you screwed up and someone was able to find a digital footprint and trace you back to your source. If you didn't do that, if you effectively hid your trail at the beginning, then you're not going to be in that situation. And just to quickly plug the Tor project talk that's going to go on tomorrow, please go to that. I'm sure you'll hear a lot more about ways to not find yourself in this very situation. And third, if you're subpoenaed, give us a call. Call us quickly, though. Don't wait till 3 days before, because it makes my life difficult and it makes your life difficult, and it will effectively it will minimize the chance that your rights will be able to be protected if you wait until the last minute. And we might not be able to help, but we'll at least be able to point you in the direction of people who might be able to help. And finally, keep in mind, or at least consider the much bigger picture here, at least in your own countries, about supporting legal protections that may very well help safeguard anonymity. Things like opposing data retention requirements. The information can't be turned over if it doesn't exist. That happens to be a very good thing from an anonymity standpoint. We tell people inside, the developers inside the United States, entrepreneurs, to try to design your system in such a way where you don't actually have to keep unnecessary information. It has this good byproduct of not allowing people to trace people who don't want to be tracked. Second, always keep an eye on copyright proposals. There's always overreaching in these aggressive copyright proposals. There are procedures in place to allow litigants to bypass ordinary process, and that's kind of what Dennis Hanlon did in that previous example. He used a copyright subpoena to kind of bypass the ordinary requirement to file a lawsuit, and he used this really quick, short-circuiting procedure. So pay attention to those kinds of proposals that are in your country. And finally, support strong intermediary immunity rules. It's in everybody's best interest that the middlemen, the intermediaries in this chain, don't actually have liability, because if they have liability, then there's an increased chance that they can be leaned on to either shut down your content or to force them to turn over information about you or something along those lines. So that's it. We have legal resources online. If you're interested in this subject more, you can look at EFF's Legal Guide for Bloggers. or you can go to just EFF.org and give us a call. Thanks for your time.